Jason, you good?
Yep.
Cool. I affirm in the United States criminal justice system, plea bargaining for defendants implicated in the January 6th insurrection is just. Contention 1, eudaimonia. Humans are distinct from other living things because there's a distinction what we can do and what we actually do. Her says so too. It's true of all other things that axes don't, they can't. No sense to say a polar bear is a bad polar bear, because far from defending young has to be running from killing them. Polar bears just don't act that way and cannot unless they mutate, nor make sense to say male cheetahs flourish more or drones than worker bees. Concepts constrained by what members do in virtue of rationality. We are different, no knowing what we can from what we do, can assess and change with other species unless we interfere necessarily so with us, not in our essence. The females bound to do what they have. We have room for idea we might be and live better, genuine, transforming effect. Rationality has unstructured naturalism doomed. It depends on identifying what is characteristic and pleasure and pains. Too much variety, irrational way, a way we can see is good. Reason allows us to access moral facts. Our reason-based intuitions necessarily come first, since every argument starts in unjustifiable beginning. McNaught 19. Number of truths known by reflection include mathematical truths, moral principles, essential natures, revealed intuition. Intuitions are fundamental, not derived from something more basic. Empiricism is mistaking concept acquisitions or concepts not acquired from sensory data. Among these concepts, right, wrong, good, bad, nothing. Answers these can be grasped to pick out properties of vagueness as we possess these. Empiricism must be false. Other concepts that cannot be explained. Infinity, number, equality. It is reason that is the source of such concepts. It's more important that we foster the character to make good choices. Other ethics fail since they put the horse before the cart. So agents and we violate universal principles. Alpha Noah's 21. Among theories criticized for reliance on universal principles were Util and Mill's GHB, Kant's CI based on obligation that is meaningless in secular society, make no sense without a lawgiver called for return to virtue. Morality characterized by Kant, notions such as duty, blame, ethics encompasses emotions, reject to make room for justice. Instead of what is right here and now, what kind of person should one be to get it right, whereas consequentialism based on rules gives action virtue, makes use of character. Character traits are stable, fixed, reliable disposition of an agent. Possesses kindness, we would expect her to act kindly, natural tendencies can be encouraged and thwarted. A virtuous actor chooses virtuous action knowingly for its own sake, right response to either to it will learn too much, judgment of a whole life, than one isolated action. Our intuition to city rejection of utilitarianism is neither possible nor feasible. Multiple warrants, Harry 20. If in our power to decide number of inhabitants, maximization would require huge populations of unhappy beings to smaller, happier ones, switching from total to average sustainable. We have to choose between happiness and equality. One lowers all statistical content same. Do we ignore higher values? Is the psychopath's pleasure as important as pain in the process more? Are you good attempts to define it in experiences? We can always ask yes to this question, what is good? Our minds understand this valid question and the two separate. We must know good intuitively. Calculating consequences of our action from here to eternity is impossible. Even impossible would take too much time to be practical. According to classical utilitarianism, appears to be the only way in which officer could prevent lethal rights. Is expected an innocent person make this duty. Anyone who's reflexive would stop writing as the utilitarian obligation to volunteer. Refuse this understanding on account of its conditional nature and the ability to ever truly resolve cost-benefit analysis down the road. Gainer 10. Util is conditional, different answers to what utility is. Shouldn't be conditional on assumption will have happiness. Is correct to maximize the possible. How do you compare intensity of pleasure? But can you do pain? Even you could compare pleasure and pain. They're often possible to reach in advance or even years later. The accident 3 months out, good or bad. It obviously had devastating effects, but was a catalyst for changing curb power policy. Can't say whether benefits outweigh. Laws are just and unjust in accordance with fostering virtue. As the topic concerns governmental decisions, you as judge ought to strive to be a virtuous decision maker. Zephyr 24. Eudaimonia explains laws and ways of government to the good life, function, the polity, promote the good life of each citizen, justice, virtuous person function well, in way of political animal, just polity function well, in way of polity functions of society, to enable members to achieve eudaimonia laws are just the extent those living are able to flourish eudaimonias. Politics represents attempt to reconcile what Aristotelian theory with Kantian political theory. Laws oriented towards flourishing does not imply legislating ways of life and against will of those subjects. Means creating a political environment in which individuals choose to live, being able to make choices part of what means flourish. Free choice, important component of that good. Contention 2 is insurrection pleas. January 6th rioters pled guilty, but Trump is trying to pardon them, overturning it. Richer and Chuckleman 25. Largest prosecution in history of reams of evidence, 1,500 cases. Trump's called political prisoners. Federal crimes, oath keepers and proud boys, extremist, seditious, conspiracy. Time behind bars, community service attacking. Police with makeshift weapons, 100% trial, 25 new arrests, and Trump's victory. Scope of harms remains unclear. These agreements ought to stand. There's a meaningful difference between perpetrator to accept a guilt and those who refuse. That aligns with possibility of moral improvement. Robertson 9.3. Abolishing plea reduction is an ethical defensible element. Difficulties are practice, not principle. Critics focus on wrong convictions. Ethical benefits disregarded without GPM. Defendants proceed to trial, consider two offenders, one accepts guilt in court. Contrast with accused who disavows wrongdoing despite differences, same penalty. Moral distinction obscured. Court could thank the defendant, leave it at that. Need for a reward. To encourage virtuous decision, we reward people for ethical behavior, reinforce our feels upholding, offer incentive for offers. It's ethical objection to acknowledging plea without a reward. Rewards insufficient reward for offenders' significant protections. The justification relates to offenders' culpability that should not ignore defendant, accept responsibility. People blame themselves on wrongdoer, accept responsibility, pleading guilty part of virtue character crime in the heat of the moment. I instead of arousal decision, plead guilty after considerable reflection. Such real reform character may emerge. We discard moral improvement, we possibly with about order. Systematic ignorance to acceptance of guilt from all formal and informal disciplinary regimes. Hearing confession what pretty serious penitent. At least sound to extend leniency when offender acknowledges guilt, denying reduction of unethical, denies opportunity moral failure, but state defendants aware of guilt, where reward for expression of responsibility. Defendants here and innocent shift divorce. Disregard reduced sentence. No coercion. They willingly gave up devices early on. Deck offense will be too generic. Hasek 21. Might expect a DOJ presser of Jan 6 defendants into plea deals that isn't what happened. 50% entered guilty pleas. Most got good bargains. Defendants' willingness to plead guilty early on cooperate with law. Enforcement turning over electronic devices, social media. The AF affirms these are legitimate bargains in line with the law. Fisher 24. Prosecutors urging judges not to undo convictions. Defendants waive their rights to appeal. High value on finality. Courts have declined to undo waivers, enforcing benefit that both parties use appellate rights as leverage. Ethical frameworks around furnishing are valuable for social justice. They're necessary to avoid cynicism, which points improvements to damage accountability. Varnell 24. Moral frameworks matter when you're trying to build future societies that work towards how is a question of your overriding goal. The response is, why do we give a shit about exploitation? That is a moral argument. Who cares? Why do you want to get rid of oppression? You need a mathematical answer. How are you going to justify that? If you care about emancipatory politics, why does the defining oppression matter? Why change it? We do have deep commitments to making moral judgments when we don't think these through. Forms of system end up refracted in political culture in ways that are destructive. Allow people off the hook for violations, dampening effect. Negative begins after virtue by talking about moral disagreement, teleological development, purpose-oriented structure to human life. To unify these disparate systems, we can provide an Aristotelian picture of the telos of human life. A lot of discourse is seemingly hopelessly emotive rather than reflective. It's not enough to recognize things are bad if we cannot explain why this is the case. For min plus 22. Buddha tells a man wounded by an arrow his friends call a surgeon, but the man will not have the object removed until he knows many things. Absolute certainty is impossible. We have to remove the arrow. This is not anything about philosophy. We can't be hamstrung by tautological theories, especially for removing poison and leave philosophers to their books. This ideology raises what kind of struggle is worth our efforts, what goal should we aim for? A response is that this is obvious. We care for the oppressed. It's not the act of being second-rate importance. It's that something is important is affecting people's lives requires some justification, intellectual maturity. Demands an accounting of our ideals. We have to care we are right, knowing politics are grounded in an accurate conception of reality. We need a systemic appreciation of our conception of human flourishing. We need philosophy. I'm good.
Okay.
Yeah.
Vontrez. Good. Okay. January 6th plea bargains. Have these already happened?
Yeah.
Okay. Are there any still occurring or haven't happened?
We are saying that they are legal, they are good under force of law. That is our argument.
Wait, what does the AF do? Is it the status quo or is it fiated?
The AF status quo.
Okay, you say that the AF affirms that these are legitimate bargains.
Right.
What does that even
So,
mean?
in the future, Trump is considering pardoning these people, and other judges are actively considering that. The AF affirms the status quo durably, in the sense that we say that these bargains ought to stand. That's our argument. We think that that is a defense of the status quo. We're just saying in the future things might not be this way. We say
why
they should
can't
be.
Trump just not pardon these people?
We think that even if he doesn't, that would still mean that the plea bargains are good. Like, I don't understand why that would be competitive. Like, if you fiat counterplan Trump doesn't pardon these people, then they keep the plea bargains, which means you're doing the AF. Like, that's what we're doing.
Okay, keeps the AF. All right, what's a virtue?
A virtue is a trait that we can deductively recognize as valuable in line with our moral intuition.
Who is we?
I think that we've made claims that us as human beings in the room are able to deductively deduce moral. We are able to deduce moral.
Why do we
principles.
deductively deduce the same virtues?
We think that we could read evidence on this question, but our argument would be that across cultures there are certain shared characteristics. We think the language of virtue in particular can be valuable. We think that various groups like indigenous societies have had their own conceptions of virtue that align, even if they call them something different, they align with the same ideals.
Okay.
Like, there are virtues in every major world society.
ESSEC doesn't seem to say anything. It just says they gave up their devices. Why does that mean?
They showed willingness to cooperate. Our argument, well, this is twofold. One, we think that coercion is not necessarily an intrinsic wrong, because like if your teacher tells you to do your homework, it might be coerced, but that habituates virtue. Two is that it says that defendants wanted
so we should
to
coerce people to be virtuous?
To some degree, yeah, because like you would have, like if you're like have kids, right? Like they're not like intrinsically good, right? Like you gotta like teach them right values. That's our argument. Like that's our view of like the role of laws.
Okay.
But like the fact they turned over their electronics took them very early in the process.
Why was a plea bargain key to this?
What?
Like you said that these plea bargains were good. Why couldn't they have gone to trial?
Why can't they have gone to trial?
Like why couldn't they have
We think they should have been rewarded. Well, I mean, they're getting rewarded. Only 15% of January 6th defendants took them, is what the first card says. The richer card. So our argument is that there's a distinction between the 85% who didn't and the 15% who did. Our argument is that we should reward those people in some sense.
Okay. I'll send it back. It's, I think, 5.
Cool.
It's actually 6.
Okay.
Wait, it's a...
I don't have it yet. Oh, just got it. Let me open this.
I'm ready.
You said 6 loss and then case?
Yeah.
Okay. I'm gonna open the doc. Okay, I'm
First off, T-Celsius, that means all seriously only 70 degrees of the word that have not been used. That connotes all specific abuse of ordinary common sense that reference to a group as a whole, and especially particular nouns from a 10 definite article intended singular noun to refer to entire class negate what is decision. The rest is the only base of research. Anything else obviates. Pre-determined and prep to its limits is actually application and to use cherry-pick cases. Discharge coordinate often broad objections like accountability like a terminal committee enters. First debates about norms such as others not abuse kinds of substance. Next up is T bargaining. Interpretation. Apps can't deviate. Apps have to. Actually, I'll come back to this. The standard is hedonistic act, utilitarianism, pain and pleasure are normative foundations for at least intersection hijacks their offense fell below. 24. Just because we desire pleasure via experience does not mean we should question. Pleasure is dependent on evidence and to commonly be determined by self-observation and empiricism. Rejects a priori knowledge and understands reasoning as a natural process. The way we figure out what is good is by relative analysis of the evidence we can offer for normative claims and valid consequences. States are made of multiple actors and varying types and must aggregate since trade-offs are inevitably inevitable in policymaking. Execution ways criminal to rights only rights only make sense in the community, so we're in the collective agent that ends up share is essentially important. Therefore, extinction is bad. If extinction humanity promoting actions are thrown to central planner causing extinction over undermine itself, it'll have less its reason to exist goals to become meaningless if it were last preventing it is greatest. Virtue it limits all trace that makes reflection impossible. If Alexander's consent is irreversible, at least I think that's a virtue. If you disagree, that if the one here disagrees, that proves that there's no universal concept. Their objections to calculating impacts are false. In armchair truth theory, utilitarians insist we must actually reduce utility if we have not predicted every consequence. Consequences of failures on a reasonably foreseeable consequence. Suppose it gives sickness, different unforeseeably. The pattern of the nice reminds her of her husband. The memory makes her voluntarily kill him. The cause of her is her act, not mine. Her act intervened in the causal change, even if she slipped and fell in consequences. Falling intervening actions results or not. Cause of acts further back. Next off is the impeachment counterplan. The United States Congress also unanimously announced their intent to rapidly impeach or remove any president whose administration passed a policy to ban plea bargaining for defendants implicated in the January 6th insurrection on the grounds of banning plea bargaining for defendants implicated in the January 6th insurrection is a high crime. The 47th President of the United States should ban plea bargaining for defendants implicated in the January 6th insurrection. The counterplan competes itself after Trump is removed for banning plan bans. Became president unbanned for fear of his own impeachment, safeguarding governance respect to five ban. Trump has a cult that believes in anything and support him, even if he doesn't say things. Trump goes to cult one direction, guys are not a personality that can weasel. Trump is seemingly opposition ignore the Constitution and his conventions law, guys are but doesn't have the charisma. The opposition will coalesce effectively and we be elected to continue being a democracy and not check Trump cause extinction, but should they save ourselves? Just saying 24. Destabilization, biggest setback for great power company, AI powers and common disruption to the US. The pattern of democracy that descended into authoritarian regimes, destabilization likely consequence. Naked and X factor trajectory of democratic north Sudan system high levels of dissection. Illegal destabilization, which will manifest as an authoritarian regime, consequences are immense, clear for suffering extras. And comment the endpoint is destabilization and is it must be immediate. Mary Morris today is present tense B, and that means it must be true at the time of speaking. Mary Morris or present tense is a verb is at the time of speaking. Visual no isn't necessarily true. Functional alone is best. Sexual combination to opportunity causes semantics of land. Software reducing proof to text or function just as function severance, which makes the app remove target bars like benefits of the mechanism, or ups the plan, which enables microaggressive behavior, plan specific, enables eliminates all generics and possible burden against us that destroy fairness, and germanus is meaningless, and which should encourage us to Josh class where pruning effects, kills grants and the action result in the app because of the butterfly effect. The status quo is also an option accuracy, then procrastinating multiple opportunity costs for us get out Friday, wonder efficiency, plan keywords, not for extension concepts which can be used. I was researching the most portable, better for college workers, survival, CS are not goals, nibs and case or numbers is the next job to make. Don't about to skip the next off. The United States should convict defendants implicated in the January 6th insurrection without a trial or plea bargaining. Should not convict defendants implicated in the January 6th insurrection. Should rule that customer obligations close plea bargaining in the United States criminal justice system. Cordial if and only if the United States does not ban plea bargaining for defendants implicated in the January 6th insurrection. That's not after. Declaration of CL is prior banning self existential threats curtail 16 CL Alexander rights may modify treaties strongly accepted as the new rule may be sufficient when they hold out less constitutional basic requires states engage your consensus reciting conduct CL is authority to by the interest law global problems include a terrorist organization comment and WMD address the global solution and camera cell starting institution churches 16 multicore the gas even a tiny amount of energy released to the surface it will wipe out all life proposals to grow mental core as a routine exploration risk will be ignored until too late these news especially dangerous go back to the second T-shell try again. Interim asks can't deviate from scope when the plea bargaining is just requires to describe the current world. That is the definition on the counterplan. Just requires to state the current system of fiat snag was to lead to attribute injustice and to practice call for a challenge absent. In essential circumstances to describe injustice reason to support and sustain it, rendering it relevant, even facts about feasibility, and they violated it. That was cross examination. They fiat that is durably fiated. It means that is upheld, and other actors like Trump cannot overturn it, which means that it diverts from the status quo. Prefer when it's constitutional against neg prep to its limits, infinite reform acts, exotic neg prep burden, and the call to clash past individual. Please float the neg prep burden as well through his grant. There interprets the topic by direction, allowing advantages of plea bargaining bad case. Virtue ethics is a laughingstock. What is circular? There's no way to determine what is virtuous, what is good is virtuous, and what is virtuous is good. Reject circular logics. Is restate the premise as a conclusion, causing proof into repetition. 2 is the paradox. One can always question why they must be virtuous or why it is a necessary composite of their being that makes it impossible to ever provide any character for the action in the first place. 3 is consequential. The only way to tell if a virtue is virtuous if you can tell the consequential benefit of the action for virtue is from the person who does not take it for self-benefit. First house. What is egoism? Virtue ethics, right? Self-centered concession ethics was human flourishing. It's seen as an end in itself. Sufficiently consider the extent to which our actions affect other people. Class normativity. 2 is its extrinsic. The ability to cultivate the right virtue will be affected by external factors beyond control, like education, society, friends, who depends on external luck. Nosing. What is institution? Just because someone has good character doesn't mean that they can't do bad things. There are certain things that can happen to people which instinctively cause bad actions, or a real choice is impossible. McNaughton. What is codify? Virtue not non-codifiable. My Sterling can claim he's virtuous and knows the resolution is false because he possesses a virtue, but he can't claim virtue. Virtue theory implies that the resolution is false. 2 is it self-defeating. We learn virtues from virtuous people, but is it possible to verify these virtues or not? Now, Zenfeld, it's subjective. Different intuitions about what virtues are. Means that's not universal viable. Now the contention proper. Negate. One is lying. Bargaining cultivates vice because it courses into innocence into lying towards responsibility, which inculcates vices of cowardice and manipulation. Libya 6, just a man, offenders be charged for all crimes committed. Prosecutors should not drop charges if a reportable case exists. If allowed, they are not attempted to punish guilty. Bargaining produce outcomes are innocent. Please guilty for promise to prosecutor drop other charges to defend the same offense. One please guilty, the other found guilty after trial received different sentences as a different offense. Can produce also exhibit different culpability. Negotiate police unlikely yield sentences related self-attracted more likely. Find defense skill, held protected. Show the case political importance. Has it gets horrible. Does not say that they were not coerced to do so, just that they did. It's true that you pleaded guilty even if I put a gun to your head to do so. Fisher says nothing, and trust. 2 is trust, bargaining condition, leniency, unwavering rights. Spell 2, people by nature, apparent defendant. 2 and 3. Rights, right to a jury trial, right to confront witnesses, right against self-incrimination. Prosecutors refuse to negotiate with the defendant until he waives right to counsel. Provision, with a right to appeal, means that ineffective counsel will say, lordship should not represent conflict of interest, jurisdiction allow prosecutors to include waiver. Go back to coercion, proves that you cannot waive between virtues.
Okay. Cool. Are you good for CX?
Yeah.
Alright.
Actually, there's I modified one of the texts for CIL.
Okay. Can you send it? Yeah. Did you modify any of the other texts of the counterplans?
No.
Okay. CX.
Yeah.
So justice requires sustaining the current system. We sustain the current system and say moving away from it is bad. Why do we violate?
That was cross. You said that.
In cross, we said we affirm the current system.
Wait. You said you durably fiat that Trump doesn't.
I didn't say the word fiat. I said that we durably affirm. Yes, we are in agreement that we should not change it because your evidence says to call for change is the opposite of calling it just. We are saying we should not change.
No, you're saying we should change because the status quo says your Richard Evanson says Trump is trying to pardon them over.
It says he may. Okay, I want to talk about something else.
That means that it's no longer.
The possibility. I want to talk about something else, Jason.
Okay.
The argument that you make on the impeachment counterplan.
Yes.
United States Congress ought to unanimously announce intent to rapidly impeach or remove any president to ban plea bargaining. So this says that it removes anyone who says they want to ban it, right?
Anyone who actually bans it.
Wait, so how does this compete?
Because Trump bans it.
Okay, why?
What do you mean why? That's the last sentence.
Okay, wait, so.
It says the 47th President of the United States should ban plea bargaining for defendants implicated in the January 6th insurrection.
Okay, I want to talk a little bit about the counterplan that's multi-plank.
Okay.
The first couple planks.
Yes.
What do they do?
It
Should convict, should not
defendants.
pardon. Okay, like what does this do? What is the net benefit to that?
The 2 counterplans after that, injunctions. Yeah, sure.
Injunctions? You mean impeachment?
Impeachment, yeah.
Okay.
Impeachment and the 2 counterplans after.
I want to talk a little bit about the first T argument.
Okay.
So why does the control the other words?
in the United States criminal justice system means that you must defend plea bargaining in the entirety of the
So
United States
you've
criminal
defined
justice
the word, the term in the United States means
I didn't
all,
read that.
what?
I didn't read that.
You didn't read that?
Yeah.
Okay. Okay. I want to talk a little bit, wait, so did you only read the first card?
Saris and Perelman.
You read what?
Saris and Perelman.
Saris
so
and
the first
Perelman.
two.
Okay, cool. I want to talk a little bit about the case,
Okay.
the argument that you make about egoism. Can you explain it?
Yeah, there's the answer to Hearst House. It says that virtues are not universalizable, or like just because we act in a way that may be virtuous, it does not mean that other people should also be virtuous.
Okay, that's time. I'll take prep. Sorry, 4 minutes. I'll start right now. I'll stop prep there. 125 remaining. I'll send it back. Name it. YR. What round is this? This is Meadows round 3. Okay. Oh shit. Prep what? Send it.
Okay, I'll let you know when I get it.
Cool. The order is going to be it's going to be the case, and then it's going to be I think it'll just be T subsets, and then it'll be T is, and then it'll be Util, the Counterplan, or it'll be core drilling, then CIL. Okay, so it's gonna be, I guess those are the same thing. Sorry, I meant impeachment. Okay, I'll give that again. it's the case, then it's going to be T subsets, T is, Util, the CIL, core drilling, whatever counterplan, and then it's going to be the Trump impeachment.
Case, T subsets, T is, util, advantage multiplane counterplan impeachment.
Yeah.
Okay. Let me see. Just let me down.
Good.
No, still. Okay, good.
It's not circular because we have the same intuitions. They have no evidence for this claim. Util is equally circular because it says pleasure equals good. We can't always question it if you habituate it properly. It being consequentialist is wrong. We have a different way of evaluating consequences. The Hearst House evidence objections, the egoism argument, we link turn this because virtue ethics and habituating virtue through law is the only way to make an ethical egoist care about others by teaching them from a young age. The collapses argument is wrong because we influence those external factors through the law. That's Zetfeld. The McNaughton evidence saying it's non-codifiable is wrong. Actor Spec solves this, and not being able to know a virtuous person is solved by finding people who are simply better in ways that you think that they have better characteristics than you are. Now, Zetfeld not being objective, ethics don't need to be objective, they don't have an impact to this, but we can still prove that ours are per above. Bargaining equals lying is wrong. They didn't prove that these people in this instance did. Our evidence says that they did the thing and attacked the police and had footage of it. Lying is not an intrinsic bad, it's about the emotional disposition when you do it. Saying it's not coerced is different than having a gun to your head, willingly giving up your phone and social media after being caught on camera is the same. Bargaining, putting leniency under giving up rights, yes, that's why it requires a reward. Otherwise, they get rid of it, which means that there's no difference between those who pled guilty and those who did not. Now, we meet. It's good in every part of the U.S. The exact text of the res means all areas. HR 140423. The term in the United States means all areas. In means within, colon 52. In, within, obviously the word in does not mean throughout. Not aware of any authority for ascribing such meaning to the word in. Prefer it. 1, context. Or actually 1, overlimiting. 1 AF means the neg has 2 months to write a perfect 2NR and wins every time. 2, AF ground. If it's not an AF, it's a counterplan, except they don't need to solve the advocate and unifying deficit out of one person are impossible. They get abolition, impact turns, and precedent setting uniqueness counterplans. 3, reasonability on T, with the bright line of being in the literature to prevent substance crowd out, intervene on theory if it's close. Now, the other T argument. We certainly sustain the status quo. We say that challenging it is bad. We said in cross-ex we didn't fiat. We said that it's good. We don't need solvency for this because uniqueness doesn't matter in these debates. We say that the value statement of it is that those things are good. It doesn't divert it, just prevents future diversion, which is from their definition of justice, which is this is a non-argument. Util. Bellum is wrong. They dropped the naturalistic fallacy, means that you can reasonably understand that there is a distinction between pleasure and good because there are ways to get pleasure that are not necessarily good. For example, psychopaths killing people. Empiricism is false because we can understand concepts like infinity, which you've never seen in the real world. Multiple actors is solved by the Senate Armstrong re-highlight. We're going to insert Grunwald is about rights. Extinction is not a direct result. It's a choice of other agents. And defense begs the question. Saying it's a virtue if you disagree, that's not a characteristic. That is a maxim, which is different. We said rules-based ethics fail, which they dropped, that agents will always misapply them unless you priorly habituate the virtue in them. So this analytic is wrong. The Senate Armstrong card certainly loses them debate. You should remember when you judge this exact argument and voted on it at Loyola. We're inserting yellow. This is their highlighting Senate Armstrong 24. This means the principle of intervening action is true. You're not culpable for how bad actors like Trump destroying democracy use plea bargaining because those are done by other rational agents with their own culpability that you ought not be responsible for. Now, the other counterplan, the core drilling, perm, do the AF, and don't core drill. No card says core drilling is happening now means that you don't stop it by voting for them. If and only if is a voter because it ensures that they can be in infinite disads, which is an impossible burden for the affirmative. Even if it's new, that doesn't justify this because it means they could have infinite offense and we could have no recourse. The CIL stuff, they need 1, they're missing evidence that 1 instance is enough to spill over. 2, they have no evidence that this is even feasible because there's no reason that this is part of customary obligations because they have no evidence about that, which means it wouldn't even spill over because there's no obligation to rule on. The other counterplan. Perm do both. The plan codifies that the president can't do it, which means it is functionally the same thing. They add on a function. They wrote the text wrong. It says it stops anyone from banning it. It doesn't actually ban it until the last plank, which means that if we do the first plank, then that does not sever. Something can still be good even if it's not immediately true. If I say that I think that eating cookies is something that is good, that can still be true even if it is not immediately the case because it is a value statement about the thing. They agree that it is good. They immediately remove Trump since all the planks happen at the same time, which means perm do both does not sever. No, if they try to make text textual competition arguments. Functional in text is best. It's key to germaneness. That is possible against new apps because this topic isn't that big. Proven by our functional limits argument. No microaggressive behavior because you could always end the round. The app is not a moving target because there's no such thing as textual sufferance. And the butterfly effect is wrong. Well, actually, we'll concede that.
4 minutes starting. Order's just gonna be T.
What T?
Subsets.
Awesome. Oh my god.
Actually, it'll be the if and only if order and then T.
It'll be if and only if voter and then T?
Yeah, briefly.
Okay, that sounds good.
I'll attach 2 of our cards on the one-air dock. Okay. Set. Okay, so advantage counterplan.
Okay,
the sound thing? Oh, you did. It's my fault. Okay, I'm good. Wait, 1 sec. Is there an overview?
No.
Okay, I'm good.
Or what do you mean? Yes, there's gonna be a brief overview on T.
Wait, I just want to make more columns real quick.
Okay, you're good.
Okay, I'm good, man.
Okay.
If and only if counterinterrupt we get if and only if it is impossible to define drop the argument. It's also other offense they get rid of the beast part, and there's a positive time trade-off because we spend time reading it and the one to see is keep discussing parts of the affirmative, especially on a topic where the opposite status quo and there's no uniqueness. Now, T. Our interpretation is that thou means all, and affirmative so true that all plea bargaining in the U.S. criminal justice system is just. That's serious. It cites Webster and defines the, and it's a reference to proof as a whole and rules that is the ordinary and common sense definition of the article. Plain meaning outweighs Scalia 12 words are understood in their ordinary ordinary everyday meaning. Most of the fundamental semantic rule of interpretation, it governs the Constitution. Such a rule and interpretation should not define arcane nuances or discover hidden meanings. True of all legal instruments. Extend when it's parallel. The in front of a singular noun refers to an entire class, which applies to the resolution. For example, the emperor penguin is territorial, refers to an entire class of emperor penguins. Parallel is Webster cites. It's an official English writing guide from MIT, which is definitive and force people around the country constructing common meaning. Now the latter line from the top. First is we mean this is wrong. It is they do not mean because they do not defend plea bargaining in the entirety of the criminal justice system. In the criminal justice system modifies plea bargaining, which means that they have to defend it throughout. They only defend it in one specific sector, one location in the jurisdiction in which January 6 insurrectionists are. Now, next is the counter-interrupt exact text. You should reject it because it's entirely imprecise. It defines in the United States, not in the United States criminal justice in the United States criminal justice system, and it only applies to that specific only applies to the specific resolution that it's defining. The first line above it says it only applies to this specific piece of evidence, HR 1404, and it says all areas within the external boundary of the United States, which obviously is distinct when it's cross-applied to a term of art, including criminal justice system. Next is in means within. The framing issue on both these definitions is that you should make them when every definition affirms, and winning one is sufficient to negate. The debate ends when the winner did not counter-define the. What they mean when they say other words in the resolution means some is that they permit selection and specification, but if any part of the resolution, i.e. the, forbids it, that means that other words are vague, and this one clarifies. In means throughout Pacific 87, in conferred throughout. Now you should reject it under precision. The Cullen evidence, the site literally says that they are dissenting, which means that it is imprecise. You should reject it when you research for evidence. You obviously look for majority opinions, otherwise you could have any contrived definitions. Now, I'll do the debatability debate proper. Vote neg for limits and ground if they win the debatability outweighs. Their inter breaks the topic and allows singular crimes. Center states proven plea bargaining is good when it's on paper, which exposes neg prep burden. Only tie the after distributing stance in favor of plea bargaining provides for predictable research. I've inserted salty advocates for numerous apps that have unique angles versus the deterrence they set and frame out case terms. 1 is antitrust, 2 espionage, 3 organized crime, 4 conditional and outward pleas, 5 domestic violence. There is a unified generic for all of these different applications. This sets require wide shifts for them to be substantial, and there's thousands of plea bargains happening daily at every level of the criminal justice system, which have 20 plea bargaining takes place tens of thousands of times. It's over 95% of all convictions. Bargaining is not objective. It is a CJDS. You should heavily err negative, especially when you're considering that they can get past cases as well. I'm considering everything in the 1 year about the moral statement thing, which means that they can defend individual past cases, which makes the negative preferment impossible because there's tons and tons of past cases that they defend that we don't have links against. That means that perception links are thumped. Predictable limits comes first. Every app opens up an entirely separate lib base. Many videos have specific purposes, like encouraging cartel members to stitch other friends or resolving docket overload in California. In different sectors of the CGS require new links and discounts. Expanding the topic over such as research, creating prep asymmetries like sector of the day, apps the neck can never prepare for. Their counter-interrupt literally allows for apps like plea bargaining that doesn't cause extinction is just because it is a moral statement. That is their words. And if you think that this also, though Tuar will say this also applies to pigs, but that doesn't matter because we're going for precision. Now the pigs and Afghan standard proper precision outweighs. The resolution is the only basis of private debatability, never justifies post active topic adjustment, we'd lose a month prep. If they decided banned cigarettes was more fair or educational, because that isn't the topic we prep for. You should reject probabilistic framing. Precision is binary. Either the means all or it doesn't. If we're right, they lose because all ground on their model is concessionary. Community consensus norms aren't able to solve for precision. There are different interests in every round. Make true community consensus impossible. It's irrelevant if debatability is the terminal of precision, because we're learning that precision is the stronger internal that determines limits and ground. I'll answer pigs proper. One is competition. Parent arguments like counterplans must be textually and functionally competitive means that minor exception pigs fail. They'd have to remove a major part of the plan text. But if the pig does compete, the difference must be large enough for the counterplan to not be significant, guaranteeing disagreement and deficits. 2 is that they lose. The expensive ask is straight term net benefits to structural plans about plea bargaining being inherently efficient. Competitive success is proven on the college alliance topic with NATO withdrawal and the college anti-trust topic with socialism. 3, worst case, read a fill-out. They can argue the entire maxim is obligatory, which means that pigs always lose. 3 is theory. But if pigs are overpowered, the app can beat it with theory. LD judges are willing to vote on it, and if the claims are right, the empirical case would be overwhelming. Next is the separate app ground standard. It's a non-concern. The app can innovate new advantages based off emulation globally, like plea bargaining, which is middle ground because the neg still gets links. Now, functional limits. You should hold the line. The one here just says that these check, but I'll answer them individually. Abolition K does not check it because they could just say perm other instances or extinction outweighs. Extinction outweighs in every other example. They can delink. That is cool specificity. Even when there are links, they always list a better and more specific one-year evidence that is specifically about the advocacy, since the app can over-prepare. Things like impact terms also apply to pigs because they can impact turn the net benefit. Last is reasonability. 1 is precision. Reasonability is incoherent because the counter-interp is either precise or it's not. You cannot be reasonably precise. 2 is that they're not reasonable. Their interp justifies tens of thousands of different apps with no common theme because they get individual jurisdictions, specific crimes, or even specific criminals. Reasonability is arbitrary and causes judge intervention, which kills fairness. Topicality is substance, which turns their education center. Look, the one here concedes the definition, which means precision is that there's no 2AR on precision, and limits is massive, especially when they get individual past cases, and the res is a moral statement, which means they can specify results.
I have a minute and 25, I'll start now.
I realized the case list wasn't in the doc. I added it to the email.
Okay.
It's gonna be T. Or case T. Good.
Yep.
Hello. You can come in. The tour is about to start. Or were you just waving? Okay, bye. Vote Applic's plea bargaining is virtuous drop. 2 true arguments on T. 1, we meet their interpretation because they are about parts of the CJS. We agree every part of the CJS, but that does not mean every plea. They have not defined the CJS, but the parts are courts, police, etc. We agree plea bargains are good within that. 2, they drop vitally that pigs don't need solvency advocates, whereas apps do, which means that debating substance is inevitable, but is inevitably worse for the 1AR than it is for the 1 in C. Now, the first argument about the means all, so we must prove all plea bargaining. The modifies the United States criminal justice system, not plea bargaining, not the plea bargaining, which means this is mostly irrelevant. relevant. We truthfully meet because it is throughout the US, which is the card that we read, saying it's a singular noun is false, because the United States criminal justice system is not a singular noun. This is the worst argument that they could possibly make. Saying that we don't meet because we don't defend the entire is liquidated above, because in the United States means all of the territory of it. Our evidence outweighs on intent to define, because it is from Congress, it's throughout the territory, it's good. This is how Congress defines it in terms of real world policy making. They just super messed up because they didn't define CGS. So the other argument is a non-starter because Congress is defining it now. They said we must win that our definition affirms without counter defining it. We don't need to define the because in comes prior to the, because it means it doesn't need to be the entirety of the, it just needs to be the entirety of in. But if in means that it doesn't need to be everything within it, then what the is changed by that. Their evidence has no authority that is better than ours. Regardless, we still meet. But debatability outweighs if they win that, because it is the only reason that precision matters, something they agree with. Nonetheless, community norms inevitably shape this, but it does not matter if it is slightly more predictable, because we have a floor of predictability, but being debatably screwed or predictably screwed in every debate is nonetheless worse. Now, singular topic, plea bargaining on paper, tying the app, etc. All of these arguments, you should think about it like this. You should think about it how much worse it is for the 1 year to debate this than it is for the 1 and C. They said there isn't a unifying generic. They're correct. There is at least 3. If you think that this is bad, think about the Eudaimonia Counterplan and sex offenders picks that have been read. We said one-person counterplans in the 1 year, which is empirically proven. Even if there are different purposes, they always get to ban it, which answers their limits argument. If sector of the day is bad, it's worse when the net reads it, because we will not have a deficit prepared, which means that we will lose the debate, whereas they, when someone breaks new, will always have things that they can say, like the counterplan that they read about Trump, and any number of things like they could have like other counterplans that ban it, like the ones that their prep group reads about unconstitutional conditions. Now, plea bargaining not causing extinction being just, you need a solvency advocate, which takes that out. Now, debatability not justifying it, probabilistic framing. Yes, probabilistic framing, every argument is probabilistic. There is a risk that we are right about our interp, because ours still says that that is a possible one that cites past court precedent, which means that we still have somewhat of a precision link, but we still explain why our debatability often so much outweighs. Text and function doesn't take it out, because better text writing means that people will make picks that are competitive by saying that it is only just in certain instances without using all the words of the plan. They don't lose because expansive asks might straight turn it, but that's false when it comes down to things without extinction net benefits. Think about it like this. When someone says that sex offender plea bargains are bad because sex offenders get out early, how do you impact turn that? This is nonsensical. Now, the argument about the entire maximum epistemic modesty style args nuke this because our deficit is never as big as our benefit, in theory doesn't check, because that just causes substance crowd out, which they drop, still matters under their competing interest argument. We explain generics that apply, debatability matters, we meet.